Good day, everyone. My name is Giselle Andrade, and we are the Group 3. Today's chapter, we will be discussing the Chapter 7, which is Labor Law Management in Tourism Establishment. Today, we'll learn about different management rights, kinds of employment, benefits, just and authorized causes in terminating employees, and procedural requirements before termination. One of the most important laws which any industry practitioners must know is the Labor Code. Labor Code is a set of laws or regulations that govern the relationship between employers and employees in a particular jurisdiction. The company should possess at least basic knowledge about this law to prevent legal disputes among its employees. Similarly, employees in any tourism establishment should also be familiar with this law to safeguard themselves against potential abuse and unlawful practices by employers, particularly concerning benefits, rights, and job security. Now let's proceed to its kind of employment. First is regular employment. Second is casual employment. Third, project employment. Fourth, seasonal employment. Fifth, fixed-term employment. And the last one is probationary employment. Now, let's proceed first to regular employment. So, who is regular employee? Number one who is either engaged to perform activities that are necessary or desirable in the usual trade or business of the employer, or number two, a casual employee who has rendered at least 1 year of service, whether continuous or broken, with respect to the activity in which he is employed. And number three, in Article 281 of the Labor Code, an employee who is allowed to work after a probationary period becomes regular employee. It is the nature of the activity that determines whether employment is regular or casual. What determines whether a certain employment is regular or casual is not the will and word of the employer, to which the desperate worker often accedes. It is the nature of the activities performed in relation to the particular business or trades, considering all circumstances, and in some cases the length of time of its performance and its continued existence. This means whether a job is considered regular or casual depends on the tasks involved and their importance to the business, not just what the employer says. It's about what you actually do and how essential it is to the company. Next is casual employment. There is a casual employment where an employee is engaged to perform a job, work, or service which is merely incidental to the business of the employer. An example of casual employment is it could be a restaurant hiring a musician to play background music for a special event. The musician's performance is not essential to the primary functions of the restaurant, like serving food, but it adds to the atmosphere and customer experience for that particular event. Casual employment may become regular. In Article 280 of the Labor Code of the Philippines states that any employee who has rendered at least 1 year of service, whether such service is continuous or broken, shall be considered a regular employee with respect to the activity in which he is employed, and his employment shall continue while such activity exists. An example of casual employment that may become regular is a construction worker hired for a building construction project. Initially, he may be considered casual due to the temporary nature of the project. However, if after 1 year he continues to work on the same project or on other projects for the same company, he may be deemed a regular employee under Article 280 of the Labor Code of the Philippines. His work as a construction worker would be considered regular as long as that activity persists. Next is project employment. In this kind of employment, there is a contract executed stating, among others, that the employment of the project employee is only for the durations of the projects of the employer. So an example of project employment is when a company hires a software developer on a contract basis specifically for the duration of a software development project. The contract explicitly states that the employment of the software developer is limited to the durations of that project. Once the project is complete, the employment relationship ends unless a new project requires their service and a new contract is negotiated. Next is seasonal employment. Seasonal employment operates much in the same way as project employment, albeit it involves work or service that is seasonal in nature or lasting for the duration of the season. An example of seasonal employment is when a farm hires workers specifically during the harvest season to help with planting, harvesting, or processing crops. These workers are employed on a temporary basis to address the increased workload during the busy harvest period. Once the harvest season is over, their employment may come to an end until the next harvest cycle begins. Next is fixed term employment. It is an employment with a fixed or definite period. So, an example of fixed term employment is when a university hires a visiting professor for a 1 year term to teach a specialized course. The contract outlines the durations of employment, specifying that the professor's services are required for the academic year only. At the end of the term, the professor's employment concludes and the university may choose to renew the contract or hire someone else for the position. Seafarers are contractual employees. Seafarers are considered contractual employees. They cannot be considered as regular employees under Article 280 of the Labor Code. Their employment is governed by the contracts they sign every time they are hired, and their employment is terminated when the contract is expires. So basically, seafarers are considered contractual employees because their employment status is determined directly by the contracts they sign each time they are hired. These contracts specify the terms and conditions of their employment, including the durations of their service on board a vessel. Unlike regular employees, their employment is not governed by the continuous nature of their work, but rather by the specific terms outlined in their contracts. So, when the contract expires, their employment automatically terminates, highlighting the direct link between their job tenure and the contractual agreements they enter into. Next is probationary employment. There is a probationary employment where the employee, upon his engagement, is made to undergo a trial period during which the employer determines his fitness to qualify for regular employment based on reasonable standards made known to him at the time of engagement. So, when we say probationary, this refers to a trial or testing period during which an employee's performance, conduct, and suitability for a job are evaluated by the employer. So, an example of probationary employment is when a manufacturing company hires a new production worker and it sets a probationary period of 3 months. So, during this time, the worker undergoes training, familiarize themselves with the production processes, and also demonstrates their ability to meet productivity targets and quality standards. So the employer assesses the worker's performance and suitability for the role based on predefined criteria. If the worker meets expectations by the end of the probationary period, excuse me, they may be offered regular employment status with the company. However, if their performance is deemed unsatisfactory, their employment may be terminated. Generally, the probationary period of employment is limited to 6 months, except number one, when the parties to an employment contract may agree otherwise, such as when the same is established by company policy. Number two, when the same is required by the nature of work to be performed by the employee. Sometimes kasi, it can be different depending on what everyone agrees on or what the job's all about. It's like if you and your boss are cool with it or if the job needs more time to figure out if you're a good fit. They can adjust it too much what the company needs and what the job requires. Hotel systems of double probation is not allowed. The hotel system of double probation is a transparent scheme to circumvent the plain mandate of the law and make it easier for it to dismiss its employees even after they shall have already passed probation. Imagine you start working at a hotel and they tell you there's a probation period, like a test phase, where they check if you're good at the job. So you work hard and pass that test phase. But then the hotel says, actually, we're gonna give you another test phase just to be sure. That's what they call double probation. Now, here's the thing, it's like they're trying to find a way to get rid of employees more easily, even if they did well during the first day's phase. It's not fair because it means you could still lose your job even after proving yourself. It's kind of sneaky and not allowed under the law because it's like they're finding a loophole to avoid following the rule about firing employees.
Termination of a probationary employee refers to the decision and to the employment of an employee who is still in the probationary period. During the probationary period, both of the employer and employee have the opportunity to assess whether the employee is a good fit for the job and the company. The termination of probationary employee can occur for various reasons such as performance issue. If the employee is not meeting the performance expectation or the requirements of the job, the employer may decide to terminate their employment. And the next one is serious misconduct. It refers to the behavior by an employee that is considered severe and can have a significant negative impact on the workplace or the employer reputation. It typically involves actions that are the direct violation of a company policies, ethical standard, or the law. Here are some examples of serious misconduct. First is theft. Any form of stealing, embezzlement, or fraudulent activities such as misappropriation of funds, unauthorized use of company assets, or falsifying financial records. The next one is harassment or discrimination. Engaging in any form of harassment, including sexual harassment, bullying, or discrimination based on race, gender, religion, and other protected characteristics. And the last one is violence or threat. Physical violence or threats of violence or an intimidation towards colleges, client, or a customer.
Good day, everyone. My name is Josimar Sambisi, and I will be discussing willful disobedience of the lawful orders and subordination. One of the fundamental duties of an employee is to obey all reasonable rules, orders, and instructions of the employer. Disobedience to be just a cause for termination must be willful or intentional willfulness being characterized by a wrongful and perverse mental attitude rendering the employee's act inconsistent with proper subordination. Willful disobedience of the employer's lawful orders as a just cause for dismissal of an employee envisages and concurrence of at least two requisites. First, the employee's assailed conduct must have been willful, that is characterized by a wrongful and perverse attitude, and the order violated must have been reasonable, lawful, made known to the employee, and must pertain to the duties which he had been engaged to discharge. Examples: first, failures to render service during overtime when required and necessary. Second, not following orders in the memorandum. Third, willful disobedience of lawful orders of the superior. Another ground for terminating employee is gross and habitual neglect of duties. To be ground for dismissal under Article 32 of the Labor Code, it must be both gross and habitual. Gross negligence implies want of care in the performance of one's duties. Habitual neglect imparts repeated failure to perform one's duties for a period of time, depending on the circumstances. Examples: habitual tardiness, absenteeism. Next, fraud or willful breach by the employee of the trust reposed in him or loss of trust and confidence. Article 22 of the Labor Code prescribes two separate and distinct grounds for termination of employment, namely fraud and willful breach by the employee of the trust reposed in him by his employer or duly authorized representative. Commission of a crime or offense by the employee against the person of his employer or any immediate member of his family or his authorized representatives. An employee may be terminated if an employee committed a crime or offense against any of the following: first, his employer; second, immediate member of the family of the employer, or a duly authorized representative of the employer. Other analogous causes. By implication, the enumerations in Article 32 is not exclusive. An employee therefore may be terminated to any other cause aside from those mentioned in the said article provided the act committed or the cause is similar or analogous to any of the above mentioned causes. That's all. Thank you.
283. It includes serious misconduct, willful disobedience, gross and habitual neglect of duties, and fraud or willful breach of trust. The number 2 is redundancy. Redundancy exists where the services of an employee are in excess of what would reasonably be demanded by the actual requirements of the enterprise. Ang principle kini nga redundancy is that an employee can only claim a payment for redundancy if he is dismissed for redundancy. The employer must therefore give notice or can dismiss without notice. The employer can achieve the same result by failing to renew a fixed term contract or by giving the employee grounds for leaving without notice. So basically, kini nga redundancy means it's ang mga excess or ang sobra nga, like for example, like when you, usa ka particular enterprise or a business nga nagsobra ang iya capability nga need lang na himuon or i-produce, na siya na nag-redundancy, nag-excess or nagbalik. Retrenchment layoff number 3. Retrenchment is the termination of employment initiated by the employer through fault of the employees and without prejudice to the latter. Resorted to by management during periods of business recession, industrial depression, or seasonal fluctuations, during loss occasioned by lack of orders, shortage of materials, conversion of plant for a new production program, or the introduction of new methods or more efficient machinery or automation. Retrenchment is a valid management prerogative. It is, however, subject to faithful compliance with the substantive and procedural requirements laid down by law and jurisprudence. Retrenchment to prevent further losses is among the authorized causes for termination under the Labor Code. According to a briefer by the Department of Labor and Employment, it is a termination that an employer can initiate through no fault of and without prejudice to the employees. Retrenchment is typically used in the context of a company downsizing or reconstructing its operations. It involves the permanent termination of employment for strategic and economic reasons rather than for individual performance or misconduct. Example niya is your employer has no work available, your assignment has ended, your employer went out of business, your position was eliminated. These are the examples of retrenchment, layoff. 4 is closure or cessation of business in good faith. Closure of business is the reversal of fortune of the employer, whereby there is a complete cessation of business operations and or an actual locking up of the doors of the establishment, usually due to financial losses. This is due to lack of consistency in profit, insufficient sales, and improper strategy. The lack of vision and improper formation of goals also affect the failure of a firm. That's why nahitabo ni nga closure or cessation na they need to close the business or stop their business in order to prevent the bankruptcy nga mas mag-bankrupt jud an a particular business. So need na jud nira mag-file. Or these operations to prevent further financial drain upon an employer who cannot pay anymore his employees since business has already stopped. So that's why kamo ni siya ang closure of a business need jud niya a particular business jud. Employee suffers from a disease and his continued employment is prohibited by law or prejudicial to his health or to the health of his co-employees, the employer shall not terminate his employment unless there is a certification by a competent public health authority that the disease is of such nature or at such a stage that it cannot be cured within a period of 6 months, even with proper medical treatment. Kani siya, usually siya na nahihitabo when a particular or a certain employee are nagkaadayan sakit nga tungod niya nga iya papagtrabahuan or need siya to prove that nagkaadayan sakit before niya magtrabaho, di ba? Nag-undergo muna ang mga employee, ang mga gusto magtrabaho sa particular business, mag-undergo ang una silahin medical na to prove that wala sila kuan sakit. Then and while nga nagkaada sila, since nagkaada na sa trabaho, then nagkaada sila ng sakit, kana amo siyang patunay nga tungod sa iya pagtrabaho di dahil siya nagkaada ng sakit. So kuan siya iton under hiyahin company, iton responsibilidad company nga mag-provide iton iya pan medical needs like mga medicines, iya iton mag-shoulder han mga necessities, mga kinahanglanon nito para ma-cure ang sakit ang usa ka particular nga employee. Then kuan sad nga pwede sad iya mag-send an letter nga like mag-leave for 1 month or hangtod na kung sa siya kuan nito maging okay na iya health to the procedure to terminate employment. In order to validly dismiss an employee, it is fundamental that the employer observe both substantive and procedural due process. The termination of employment must be based on a just or authorized cause, and the dismissal can only be effected after due notice and hearing. So, syempre, before nga ma-valid ang imo termination, syempre, need jud nimo nga mag-undergo pa ang due process and mga procedures.
The next topic is about procedural requirements if the causes of terminations is any of just causes. Section 2 Rule of 23 Book 5 of Omnibus Rules Implementing the Labor Code provides that for terminations of employment based on just cause of defined in Article 282 of the Labor Code. First, a written notice served on employee in specifying time grounds of terminations, and giving said employee reasonable opportunity within which of explain reside. So means that when employee demands provide a written notice should be clearly state the reason for the terminations outlining the grounds or basis to which of the decisions is made. Second is a hiring or conferences during which the employee concerned with the assistance or conserve is employee so desire is given opportunity to respond to the charge, present these evidences or rebut evidence presented against him, and a written notice of terminations served on the employee indicating upon due considerations of all circumstances or grounds so that have been established to justify his termination. Next topic is all about procedural requirements if the cause of terminations is any of authorized causes. If the cause of terminations of employee is due to authorized causes, the employee must first you need to serve a written notice to the workers at least 1 month before the intended date of termination. So it means the employee must provide a formal written document to the employee who will be terminated. So this document should explain the reason
for the terminations and indicate exact date when the termination will take effect. The notice should be given to the employee at least 1 month or 30 days before the termination date. This gives employee time to prepare, just as the looking for other employee options. For example, if an employee plans to terminate an employee on May 15, they should provide a written notice to the employee by April 15. Next is serve a copy of the written notice terminations to the Department of Labor and Employment. So, means the employee should also send a copy of the terminations notice to the Department of Labor and Employment. This is done to ensure that termination is being carried out accordance of labor and regulations, and that employees' rights are being protected. So, for example, after giving the terminations notice to the employee should also send a copy for this notice to Department Labor and Employment, either by email or other methods. Then next, normal hours and overtime work. So the general normal hours of work of any employee shall not exceed 8 hours a day. So in a typical office job, normal hours might be conserved on 9 a.m. to 5 p.m. Monday to Friday. So this means that employees are expected to work each day, Monday to Friday. So the next is overtime work. Work may be provided behind 8 hours. They provide that employee is paid for the overtime work, and additionally compensations equivalent to his regular wage plus 25%. Therefore, work performed behind 8 hours on the holiday. A rest day shall be paid, and additionally compensations equivalent to the rate of the first 8 hours on a holiday or the rest day plus at least 30% thereof. So, mm, for example, an employee's regular working hours are from 9 a.m. to 5 p.m. Monday to Friday. If they work until 7 p.m. on a Wednesday, we should have 2 hours of overtime for that day. And next, under the time cannot be offset by overtime. So other time work on any particular day shall not be offset by overtime works on any other day. So for example is the employee's regular working hours are 8 hours per day from Monday to Friday. If the employee works only 6 hours on Monday, 2 hours less than their regular hours, they cannot work 10 hours on Tuesday, 2 hours extra, or claim overtime fee for those extra 2 hours. This policy ensure that employees are paid for the actual hours they work and prevent them. Next is the night shift differential pay. Every employee shall be paid a night shift differentials of not less than 10% of his regular wage for each hour of work performed between 10 o'clock in the evening and 6 o'clock in the morning. So for example, employee who works the night shift the manufacturing plant, the normal working hours for the day shift are from 8 a.m. to 5 p.m. However, the night shift is start at 10 p.m. and ends of 7 a.m. the following day.
Holiday pay. Every worker shall be paid his regular daily wage during regular holidays, except in retail and service establishments. regularly employing less than 10 workers. Refers to the compensation or benefits given to employees for working on designated holidays. The specific rates and regulation for holiday pay may vary depending on the company policies. For example, employees are entitled to a day off with holiday pay on public holidays, with the pay rate usually being at least double the regular hourly rate. If employees work extra hours or overtime on these days, they should receive at least triple the regular pay. Regular holidays, New Year's Day, January 1, Monday, Thursday, movable date, Good Friday, movable date, and Araw ng Kagitingan, April 9, and etc. Double pay. If the employee works on the said regular holidays, she'll be entitled to 100% basic pay and an additional 100% for working during regular holiday. If the employee works during his established rest day, which is at the same time a regular holiday, the employee shall be entitled to 260%, refers to the practice of paying employees twice the regular rate of pay for hours worked beyond their normal working hours. It is often used as a form of overtime compensation or as an incentive for employees to work during holidays or outside of their regular schedule. Special holidays. Here in the Philippines, we have three special days in a year under Executive Order number 292 as the amended by Republic Act 9849 that should be observed in the Philippines. Number 1, Ninoy Aquino Day, Monday, Neris, August 21. Number 2, All Saints Day, November 1. Last day of the year, December 31. If an employee does not work during a special holiday, he is not entitled to any payment. Next is payment for work performed during special holidays. Work performed on a special holiday merits additional compensation of at least 30% of the basic pay or total of 130% if performed during a special holiday and at the same time rest days should be entitled to 150%. Next is right to weekly rest day. It should be the duty of every employer, whether operating for profit or not, to provide each of his employees a rest period of not less than 24 consecutive hours. After every 6 consecutive normal work day, the right to a weekly rest day refers to the entitlement of employees to have at least one day off per week as a period of rest and leisure. This right is recognized in many labor laws and regulation around the world. The specific day of the week designated as the rest day may vary depending on the country and industry. It is important for employers to comply with these regulations and ensure that employees have the opportunity to take their weekly rest day to maintain work-life balance and promote employee well-being. Compensation rest day. If the employee is made or permitted to work during his rest day, the employer must pay the employee his regular daily wage or 100% and an additional sum of at least 30% of the regular daily wage. In other words, the pay for rest day is 130% of the pay for ordinary days. Compensation for rest days typically involves providing additional pay or benefits to employees who are required to work on their designated rest days. This compensation is meant to recognize the sacrifice of employees who give up their time off and ensure that they are fairly compensated for their work. Next is Republic Act number 7877, Sexual Harassment Act. The law penalizing sexual harassment in our jurisdiction is RA 7877. Section 3 thereof defines work-related sexual harassment in this wise. In a work-related or employment environment, sexual harassment is committed The sexual favor is made as a condition in the hiring or in the employment, reemployment or continued employment of said individual, or in granting said individual favorable compensation, terms, condition, promotion, or privileges, or the refusal to grant the sexual favor results in limiting, segregating, or classifying the employee which is in a way would discriminate, deprive, or diminish employment opportunities or otherwise adversely affect said employee. The above acts would impair the employee's right of privileges under existing labor laws, or the above acts would result in an intimidating, hostile, or offensive environment for the employee. Next is the demands. Requests for sexual favor of superior need not be expressed. It is true that this provision calls for a demand, request, or requirement of a sexual favor, but it is not necessary that the demand, request, or requirement of a sexual favor be articulated in a categorical oral or written statement. It may be discerned with equal certitude from the acts of the offender. In a workplace context, it is illegal and unethical for a superior to demand or request sexual favors from these subordinates. The demands of requests need not be expressed explicitly. Even explicit demands or requests are considered as harassment. Duty of the employer. It should be the duty of the employer or the head of the work-related, educational or training environment or institution to prevent or deter the commission of acts of sexual harassment and to provide the procedures for the resolution, settlement, or prosecution of acts of sexual harassment. Last is liability of employer if no action is taken. The employer or head of office, educational training institution shall be solidarity liable for damage arising from the acts of sexual harassment committed in the employment, education or training environment if the employer or head of office, educational or training institution is informed of such acts by the offended party and no immediate action is taken thereon.